few arraignments that I need to call, and then I'll call the Cruz case. Anderson Collins.
Good morning, Robin.
Morning.
Roger, really have Mr. Collins. I'm probably refusing this case, Judge.
Okay, the public defender's office was on the case first. Did you file a motion for substitution?
I had filed, Judge, I sent to the public defender's office the substitute counsel, but I never received anything back from them. I think this is Mr.
Judge, we move to withdraw.
Thank you. All right, the public defender's office motion to withdraw is granted. Mr. Green is the attorney of record. I'm going to accept the plea of not guilty and set the case for calendar call on December 15th. Thank you. Mark Boyd. Okay. We're here on the State of Florida versus Nicholas Cruz, case number 18-1958. All of the lawyers are present. I believe the defendant is present. And we're here for a status conference to discuss what outstanding motions need to be set and heard, which are agreed to, and so on and so forth.
Jeff Marcus for the
Good
state.
morning.
Good morning. If I may just address something from the plea. The court asked about the pre-sentence investigation, and the state only said that it was mandatory.
Okay.
Under the rules, actually only mandatory if the defendant is going to waive mitigation,
Okay.
which isn't the case. Our position is that it's actually a discretionary decision.
Okay.
Mr. Solshine is here too. And there is an argument as to that, Mr. Solshine.
Well, it's my understanding you all were not asking for one, and then when we believed it was mandatory, then you said, I'll order one, and then we'll discuss later whether or not your client's going to submit to one, I believe.
That's correct, Judge.
So, should I just cancel the PSI?
Judge, we have to, yeah.
The state's position that is that it's still discretionary, and it's really important for this court to still have the PSI done in this particular case. The decision whether or not to enter a death sentence should the jury return one is still discretionary with the court. The jury can come back with a 12-0 decision. The court can still say that I'm going to sentence him to life in prison. I'm looking at this from a post-conviction angle.
Okay.
And it's very important that the record be clear, that it's very important that you don't want an ineffective assistance of counsel recommendation, because the PSI can have some favorable things and they waive it. That would be a real issue. If this court returns if the court agrees with the jury and there's a death recommendation.
Just as a logistic, more like a common sense question, what possibly would DOC be able to gather that his lawyers wouldn't as far as a mitigation presentation? I mean, DOC, they go out, they interview the person, they talk to their family if there is any, and they look up the person's criminal history and take statement from the person.
Perhaps there are things that the attorneys for Mr. Cruz would not pick up. Perhaps there are things which there are recommendations that they would have in their in a PSI that would be available to Mr. Cruz. And if that's not presented and there is a death recommendation, there's going to be a 3.851 post-conviction motion alleging ineffective assistance to counsel regarding that fact, that they waived that particular issue.
Judge, if there's something that we don't present that's in the penalty phase of this trial, it's going to come up regardless of whether there's a PSI. And like you said, I agree with the court. I mean, we know he doesn't have a criminal history prior to this, so there's nothing there for the probation officer to do. And like you said, we are delving into every aspect of his background, his character, everything. And that's all going to be presented. There isn't anything that DOC is going to do. And frankly, we're not going to speak to them, and he probably wouldn't speak to them either. So there really is nothing for them to do, and it's not a fundamental right. Counsel can waive it, and there's cases, Ortiz versus State, 9, 7, 3rd, 774, 4 PCA 2009, and Culver versus State, citing it, 163, 7, 3rd, 623. that it's not a fundamental right, and counsel can waive that a PSI for their client.
Your Honor, if I may, speaking from on behalf of the state, I'd like the court to know that recently I was involved with juvenile dissent on a first degree murder. It was sent back from the court because Judge Beckman had not ordered a PSI. Now, at the hearing, obviously, it was a long hearing, all the facts came out, but the court still said it wanted a PSI in that case. So I would, again, I think the state's position, or what I suggest to the court is for the time being to cancel the PSI and wait until later, and at that point address whether or not it should be over when you first into the penalty phase or toward the end of it, at the end of the penalty phase. It might take a little while for them to do it, but then it'll avoid any conflict.
So in other words, you're suggesting that if there's any concern on my part as to whether or not I received all of the facts that I feel would be necessary to make a determination, then I should order one at that time?
Yes, ma'am.
And I'm not trying to be disrespectful to DOC at all, but I don't know if you all have had the opportunity to read some of the PSIs. They're very limited. And I'm not saying they're always limited, but in a situation like this where, it's my understanding Mr. Cruz has one living relative of his brother. He doesn't have any parents to interview. He doesn't have, I mean, they don't investigate it the way a police agency would, or the way you would if you were defending him.
Well, the other thing is, for us to realize is, I understand the case law that Ms. Curtis has said this court, but it clearly is discretionary. In capital cases, the court does have the ability to have a pre-sentence investigation, but it's also important to protect the record in this particular case and to eliminate any claim of ineffective assistance of counsel. I've seen it in both capital and non-capital cases where the failure to order a PSI can be a ground for an evidentiary hearing.
So what if can I remedy that by wiring up the defendant to make sure that he runs?
Judge, I would object to that. The case that I cited also says that it's unnecessary, it's not a fundamental right to have a PSI. I would just ask the court to do what Mr. Klinger is suggesting, which is to just cancel it for now. If the state wants to re-raise this, or if the court is concerned during or after the penalty phase, it can always be ordered then, and we can address it then. I don't know what cases they're talking about. I mean, I've cited cases. I'm just asking for now that the court cancel the PSI.
Well, I mean, I'll tell you this, it's either going to be ordered or it's waived and going to inquire of him. So if you're not going to let me inquire of him, then I'm going to order it. Because there's got to be some record. Even if there's one case that says that this is reversible error, I need to inquire of him.
Okay,
So
well, I haven't seen that case.
Judge.
Can we do this on a different day when they can provide that case to me?
Judge, the cases which say that it's discretionary are State versus Perlin, P-U-R-W-I-N, and Rose versus State.
Perlin is at 405, 7, 970, and Rose is at 461, 7, 828.
Perlin is a 1981 case from the Supreme Court. Rose is a 1984 case from the Supreme Court.
And what is the case that that you were talking about with Judge Backman? Is there an appeal?
Nicholas White.
Nicholas State versus Nicholas
So
White.
is there an opinion, or it's just, too minor?
No, it's part of it.
Okay.
It also in State versus Israel, but it was a different set of facts and scenario, but it also PUZIO, State versus Israel, also has an issue with it.
Okay, I'm going to keep the order as it is. However, I'm going to ask the Department of Corrections to hold it in abeyance for now. I'm going to review the case law, and then I'll let you know. Thank you. So, okay, so you all were going to get together and discuss what,
So, there are some outstanding motions that have been filed, responded to, and some of which were raised through some art, and then there's a couple of motions that were filed, and, excuse me, the responses are coming from the state. At this point, I don't know if we have enough, we have some more coming, enough to fill a slot.
I mean, here's the thing, I'm sorry to interrupt, but I made it clear last week at the hearing, we're gonna start the jury selection the first week of January. So I have this whole week blocked off for hearings. So the fact that nothing's ready is not, we need to be able to do something. I blocked a whole week for you all, and if there's motions that are not agreed upon, then they need to be heard.
Okay, Judge, well, we have a couple of motions in limine and a couple of capital motions that have been filed, that have not been heard, that will not require witnesses, that we could do this week.
Okay, and which ones are those?
We have GP 22, 23, and 24.
Okay,
And then we filed 5 motions in limine. One of them is moved, 2 of them are agreed to, so we have the other 2.
okay, so have you presented orders on the one that is moved and the ones that are agreed to?
No.
Okay, why don't you go ahead and list those for me so that I can make a note of it?
Okay, so DMIL 5 is agreed to, and DMIL 7
Is agreed to?
yeah.
And when I say agreed, they're agreed in the current form. It's not gonna be a situation where you say you're agreeing and then I'm given 2 totally different orders and then we have to litigate it. It's agreed in its entirety.
Mr. Coney and I are going to work on presenting one unified, agreed-on order to the court this week.
Okay, that needs to be done by Friday.
Okay, and Judge, keeping in mind, of course, that, motions in limine are never final orders. And so we're agreeing to it. If one of us believes that it should somehow come in later, that's another.
Of course.
Okay.
All right, so DMIL 5, DMIL 7. So what else is there?
So DMIL 8. Not agreed. Oh, that is agreed? Oh, okay. So again, DMIL 8, okay, we can do an agreed order on that, but again, with the understanding that if we somehow bring something that opens the door.
All right, so the state is agreeing to DMIL 5, 7, and 8.
Right.
Walter Funny on behalf of the state, yes, Your Honor. As Ms. Curtis said, unless the door is open, or something like that.
I'm aware of the rules of evidence. So those are granted, and I don't even need an agreed order. They're granted without prejudice, by agreement of the parties, okay?
DMIL 6 is now moved. It was through the motion dealing with what to call the first day of the trial, but we're not having that.
Okay, so DMIL 6 is denied as moved.
DMIL 4 will need to be argued.
Does it require witnesses?
No.
Okay, so let's do that with DP 22, 23, and 24.
And Judge, so DMIL 3, which deals with unrelated firearms and ammunition, I'm not sure that the state is ready to agree in total with the motion, so they'll look at that and we'll send an order over this week, or we'll give the court a status. I mean, we'll be ready to, whenever we set the other hearings, we can.
I'm going to add DMIL 3 to that,
Okay.
to the other ones, and then if you have an agreement, you can let me know the morning of.
Okay. And D-162 and 163, I don't think we've addressed those. There's an agreement on 162.
All right, the state's agreeing to D-162?
Yes, Your Honor.
D-162 is granted by agreement.
So in D-163, Judge, it's the same motion. So basically, these motions deal with decorum in the courtroom, what, wearing certain items that could be prejudicial by witnesses and by members of in the gallery, T-shirts, wristbands, that kind of stuff.
Okay.
I believe that the administrative order that was recently issued covers 163 and does prohibit that. And that's for the people in the gallery. So
It does.
that one, I suppose, is moved.
All right, so D-163 is denied as moved per the administrative order. a motion to suppress SW.
Yeah, so we have 3 search warrant motions.
Oh, that's why it's SW search warrant.
Yeah.
I was wondering why we changed the letters.
Those will require, excuse me, witnesses, so,
Okay, so there's SW 18228, which is D165.
yes.
When can I set that? And I want to set it in stone today without any kind of changing date.
Judge, I think the state will only be calling one witness, so when is the court available?
I'm available this entire week. I'm available when you all are available. So,
We have responses that we're preparing based on the court order. They're due Wednesday, so the responses will be in. The defense can take a look at them. I don't know how quickly they need to respond or get ready from that point, but
on D, we're talking about the search warrant?
correct.
Okay, can we hear, Thursday, I had Thursday set aside for a motion to suppress it. So you all are saying that doesn't need to be heard anymore because it dealt with the guilt phase.
Judge, I wanted to press the board that if you have a number of those witnesses set their deposition on the 8th of November, because the state recently listed them as experts, so we're going to delve into their qualifications as such. These are the search warrant witnesses available.
Okay, how about November 15th? That's a Monday.
I can do a tentatively yes, and make sure that our witnesses are available and that the court knows right away.
I think on that day we have some important depositions scheduled.
Okay, so when do you want to set it? I'm clear, I will clear my schedule. I want you all to tell me when you're available, not when you're not, okay? So when can we set it?
Do you have the deposition?
I don't, oh, wait, I'm sorry, we are
That's okay.
November 15th. So, the ROTC depots, I think, were this Friday. My secretary was texting me that she thought,
No problem. So November 15th at 1:30
we're good.
for D165. State, if your witness isn't available, it better be a very good reason. Like, very good, because there are so many witnesses. I don't need to tell you why. It's gonna have to be an emergency type situation, because this case is gonna take precedent, and if you have a problem, call up the chain of command until you get that person here, please, unless it's some kind of dire emergency.
Understood.
Okay, November 15th at 1:30.
Is that 165 or 164 as well?
I'm sorry?
Do you want to do 165 and 164 as well? There's 3 motions outstanding for search warrant suppression.
I think that actually 164, the reason we filed that first, I think that one needs to go first.
That's probably the most.
Because it's the phone itself. I mean, so a lot of the motions we filed stem from searches regarding that. It's the whole
Sure.
thing.
I just grabbed 165, this was on the top of my file. So November 15th at 1:30, we'll first do 164, and then following that, we'll do 165. That's November 15th at 1:30. And then, what's next? How about,
Is there a day maybe next week? Because I think by next week we can add a couple more of these capital motions. so
Okay.
we can just do them all together.
Sure.
That's fine. Okay.
so next week is the first week of November, starting November 1st. I can do it any afternoon. I can do it Friday morning. Just let me know. That's a Monday.
November 3rd. How about November 2nd? Oh, no, I'm sorry. I can't do November 2nd. Okay, so Friday morning, I think we probably have depositions. Let's see if we're available the 3rd or the 4th. If not, we can do it on Monday. Well, no, that's probably Tuesday. Yeah. Oh, okay. Okay. Yeah. Okay, so we can do November 3rd, and we have the 3 pending capital motions that were already filed and responded to, and we will probably add maybe 3 or 4 more.
Okay, November 3rd at 1:30, and this is going to be, what did you say these types of motions are?
They're just the capital motions.
Okay.
So there'll be new motions, and then in addition to that, Your Honor, it will be DP 22, 23, and 24, which the state has already responded to.
Okay. And that's November 3rd at 1:30.
Yes, Your Honor.
And then what about, can we do DMIL 3 and 4 that day also?
Yeah, we can do that at the same time. That's fine.
DMIL 3. It's confusing for us to keep track of it because you all remember, you write the motions, you spend hours drafting it, you name it, you know it, you do the response, you read the response, you read the response to the response. So these are more than just numbers for you, for us, it's a little tricky. All right, so DMIL 3, DMIL 4 on November 3rd at 1:30. And then what else is outstanding at this point?
So Judge, there are 2 motions that are, that the court has not ruled on.
Okay, the grand jury testimony. We ordered the testimony yesterday, and I asked that I have it by Thursday. So I'll have them ordered by Friday. Because you said your depositions are going to be in the beginning of November, I believe. That's what Ms. McNeil said.
Yes.
So if I have it by Friday or Monday at the latest, the order, I believe she said your depots were like towards the middle of November.
That's correct.
So that would be enough time, I hope.
Okay.
Okay.
Judge, also the, I think it's SF 128. No, the third party negligence.
The third-party negligence?
Is that 128?
That you're waiting on an order.
Yes.
Okay.
It's with the Attorney General.
Yes.
No,
Statewide prosecutor.
No, that was for them. No, this is the one where, on the Evelyn, remember the argument about the Evelyn case and the third-party
Yes.
negligence, system failures?
Yes.
I believe it's SF 128. Hang on, I might have written that down.
You're right, the Attorney General was involved in that. That he responded.
Okay.
But that's the motion.
Okay. And the state prosecutor and the Attorney General?
The statewide prosecutors under the district attorney level.
It's the same office though, isn't it? Okay.
Across the street.
I just want to make sure.
I can tell you that all response to it is D161.
Okay.
And I'm pretty sure it was SF 128, but I'm not.
I have notes on all the hearings, so I can refer back. So that, you're waiting on an order on that particular issue and the grand jury testimony.
Right, well, and there's one other one, Judge, which we did sort of briefly discuss it the other day, but I don't think the court needs to enter an order now. It's SF 109, because that was to enter certain evidence that the state initially indicated was proof identity, which now clearly is not an issue, but we were talking, and I don't think we've actually come to any sort of resolution. One of the issues at this point, Judge, that we're trying to work on with the state is that, given that we're only doing penalty phase, there will be, there's going to be probably the same amount of disagreements, just different ones.
I understand, but I think that needs to be litigated because I believe Mr. Sachs said he intended to present that evidence.
Okay,
Even
well,
though it's
we-
penalty phase. And I'm sorry to interrupt, but Ms. McNeil said that she was intending to argue against it. So whatever form or whatever legal basis was being presented as a basis to introduce it, and whatever legal basis, that may have changed to exclude it, but the issue is still the same. So that I believe needs argument.
Okay, well, Judge, we actually waived the hearing on that, and we filed D160, which just is to proffer in opposition to it. We did it sort of the same way that we did the proffer in opposition to the crime scene case, so that there doesn't need to be, we waived the hearing, the court can rule on the pleadings, and if you want us to email the JA, because there were a few, they filed a couple things, we filed a couple things, I can email those numbers to the JA, so you know which ones apply to that particular issue.
I really will. If you can tell me, if you have a note of it, because, like I said, all of these letters and numbers, things sometimes get lost in the.
Right, well, that's what I'm saying, when I get back to my office, I'll email, because I don't have that in front of me, I'll email Ms. Lunsford the numbers of the motions the state filed and the ones we filed.
Okay, so although you withdrew your opposition to SF 109, you now are,
We didn't withdraw it. We decided we didn't need a hearing.
because it went, you believed it went to only the phase 1. And you thought the state wasn't going to be introducing it in phase 2, but they are going to try.
My suggestion is, why don't we do this, Your Honor? Just pick a day you're having hearings, we can argue. It shouldn't take but 15 minutes.
Okay, so I'm going to add that to November 3rd at 1:30.
That's fine.
And Mrs. Curtis, you said it's SF 109, and what was your?
That's right. We also need to know who the mental health experts are, because
And I thought Ms. McNeil said she was going to give that to you by.
She's supposed to give to us this Friday, but until we know that, we don't know
Yeah.
the relevancy arguments to make for this lawsuit. So that.
yeah, because there's multiple issues to the swastika issue.
Okay, and that swastika issue is SF 109.
I believe that's,
I think that's-
it's one of the responses. There's, I think, 4 or 5 items filed.
Okay, so this is what I'm going to do. I'm going to add it to the date of the hearing. And then, on that date, if you all don't have what you need, or you need more time, or whatever it is, you can just let me know that day.
That's
This
more
is
than
not
fair.
right,
That's more than fair.
and we'll do it the next set of hearings.
Okay.
How about that?
Perfect.
So for November 3rd, we have at least 1, 2, 3, 4, 5, 6 things tentatively that can be heard. And then what I would like to do is schedule at least an afternoon, 3 or 4 additional afternoons so that everyone can clear their schedule, so that even if we don't have a specific motion to set today, we have those dates set aside. Especially because we need to get into the jury selection process. I think you all have agreed somewhat on how to go about selecting the jury in the pre-selection, because that will affect a number of jurors that I will need to have the clerk's office summons, and they have to send them out early, and I need to know whether or not, actually, we can talk about a little bit about that today. That would be very helpful, because the clerk's office is really anxious about getting the correct number of jurors on the correct days, whether or not you want to have them summoned, let's say Monday, Tuesday, Wednesday, so that we have new groups Monday, Tuesdays, and Wednesdays, and then perhaps on Thursdays and Fridays do a more in-depth selection of the ones that have not been excused. Because I don't know that they summons jurors Monday through Friday. I don't know that we can get them 5 days a week. Well, you all would know. Have you ever been able to do that in the past on any of your other big cases?
Yeah, in the past we have.
And you get a new set of jurors Monday, Tuesday, Wednesday, Thursday, Friday?
I'm not sure Friday.
Yeah, I think that, yeah.
Monday through
not-
Thursday?
Yeah, not Friday.
Would your preference be, do you all know, would your preference be to get, in other words, how many days do you think I should summons jurors?
Well, I think your idea the other day about having 200 come in,
Okay,
and I think we can see how that goes,
okay,
and how many jurors you can, find
Sure.
for the other state, and then you can make some decisions
Sure.
about how it's going.
but in other words, how many days of, let's say we're working 5 days, how many of those 5 days do you want me to attempt to get a fresh group, a new group, not fresh, a new group of jurors?
As much as you can do.
As many days as we can.
Sure.
So if they can do Monday through Thursday, we'll do Monday through Thursday.
Yeah.
And,
Is that the 200 reasons too many? I don't know how I
I thought you did that before. And you said
well, we got through 200 now. It was a quicker pre-selection. It was just me talking and reading a script that the parties had agreed to. However, that was when we were socially distancing only, and we can only do 32 in here. We're going to be in the other courtroom, and we can easily fit 60. And that's with social distancing. So we can get twice as many in the courtroom. In other words, we have to take small groups of 32, and just be in and out and all of the coordination, and you have to write a new chart every time. That takes time. You see what I'm saying? So we can do 50 plus, I think 4 groups a day for just pre-selection, just pre-selection.
Yeah, I think that's good.
We had some in Mrs. Curtis, like 5 something. And I just said I didn't want to do that again because I thought that was, and then we had priority over all the other judges, so they're all waiting for jurors, and we ended up having 300 plus folks waiting all day, and we never got to them. So I thought that if we could.
Your Honor, this is Melissa McNeil. May I be heard briefly, please?
Yes, sure.
We've actually had meetings, myself and Ms. Curtis have had several meetings with Mr. Marcus and Ms. Chiapponi about this.
Okay.
And come to some agreements. Mr. Sachs hasn't been part of those meetings, but
Okay.
I'm sure this information has been relayed to him.
Okay.
I can tell you, when we were socially distancing, so we can add numbers to this, this is what the state and the defense had agreed to. We would start 5 days a week. And when we were socially distanced, we were thinking 100 jurors, 50 in the morning, 50 in the afternoon. Now, you can change that because obviously those restrictions have been lifted. Our agreement was that those days, whatever number you pick for the morning and for the afternoon, they would just be hardship, okay? Once they finished hardship, however many people make it through hardship would be given our questionnaire, okay? So they would go to a separate room and then they would be told to come back a different day. I'm sorry, not a different day. But if they survived the questionnaire, they would be contacted and they would proceed to step 2. And our agreement was step 2 would be knowledge of the case, their death views, and anything else that we thought needed to be addressed from their questionnaire and perhaps in private. And that would be an individual voir dire. We're thinking, I don't know, 15 minutes per side. And then if they make it through that, step 2, then we were thinking we could move to step 3, which could be general voir dire. And then we just need to add in some time in order for the state and the defense to review the jury questionnaires. And so that's what we had agreed to so far. I don't know if the court, and I can submit that in an order and make sure the state is still in agreement with those terms, and then let the court allocate or request the number of jurors that are necessary and whatever resources that you have to make sure are in place in order to facilitate this agreement.
Okay, that sounds mostly good. My concern is that if we only do hardship in the first group, I don't think it's going to work, because just in the last case, we had several people that reacted just by walking in. And I think if that question about whether or not these people have heard of the defendant and whether they can be fair, if it's not addressed, I think that we're just wasting time, because there's going to be, based on my experience from the last case, depending on the particular panel, there was up to, I think, 3 people that basically couldn't even sit in the room without getting upset. So I think that issue should probably be addressed with the hardship, and I guess you're calling it phase 1. We don't have to get into it in detail, but at least, like in the last trial, I just read the charges, and then I can give you all what I read, but I basically just said, is there anyone that can't be fair and impartial based upon the defendant or based upon the nature of the charges? And only because by making those people come back, there are people that are going to be very adamant. And I feel like that should be addressed in the first group with the hardships.
I don't have a problem with that. I don't know what the state's position is.
Mr. Sachs said he agrees.
Okay. So that would just be, do you know who Nicholas Cruz is, and based on knowing him and the charges, you cannot be fair and impartial. And then the step 2, we could go in a little bit more about pretrial publicity.
Sure. I'm just talking about just telling what the charges are. It's pretty much exactly what we did the first trial. Except this trial, I anticipate there's going to be more hardships because this is going to take longer than a week. And the last one, I told them they would only be here for a week. So this we have to predict approximately how long this is going to take. So the only thing that I would like for you all, I think the step 1, 2, and 3 sounds great, but I would like for you to say, okay, let's do phase 1 on these days, and then and then these people would go back and they would fill out the questionnaires. This is the time we would like allotted for the questionnaires. If you could actually like break the whole thing down for me.
Sure.
And I don't know if you want to do, say, Monday, Tuesday, Wednesday, the phase 1, and then bring the people that make it through phase 1 on Monday, Tuesday, Wednesday, and have them come back Thursday and Friday for phase 2, maybe? I don't know if you want to do it like that, or if you want to do just every day phase 1 until you get enough, and then phase 2 until you get enough. You see what I'm saying?
Yes.
Yeah. So what we can do, Judge, is set up a meeting with Mr. Marcus and Mrs. Chiappone and Mr. Sachs, if he wants to attend, just to fine tune that, and then we can put it in an order once we're agreed to it. And if then the court has any issue with what we've agreed to and you need to fine tune it even more, then we can do that.
Sure.
Are you comfortable with that, Your Honor?
Absolutely, and if I can just have it as soon as possible, because like I said, the jury room needs to know how many extra jurors, because whatever we need, then they subpoena, or they summons,
Sure.
I don't know how many show up, but whatever that percentage is, then they add it on top of the regular jurors, and then we go like that. So, and also, if we're gonna do it 5 days a week, we're getting into like civil juries too, so, we'll just, it's okay, but we just have to give some notice, okay?
So just one other question, Judge. Given that we're going to be in a different courtroom, how many people do you comfortably believe that we'd be able to have come in one day? Just so I can include that in the proposal.
At one time, or per group?
Per group. If we're doing 2 groups, one in the morning and one in the afternoon.
I believe we could get 60 per group.
Okay.
Because they have an aisle in that courtroom on the side where we're actually able to put extra chairs. I don't know if you all noticed. And then there's about 3 times more room than we have in here. And that's with social distancing, and as we all know, the numbers here are getting better, so a lot of judges are not even social distancing with jurors at all. By that time...
And then how...
Go ahead.
I'm sorry, Judge.
That's okay.
How many groups in groups of 60 do you think we can do in the morning, and how many groups of 60 do you think we can do in the afternoon? Based on those 2 issues that you covered
Sure,
before.
it's just going to be me reading the charges, saying, exactly what I did in the first trial. I think we can get through 4 groups, 2 in the morning and 2 in the afternoon.
Perfect.
Judge, do you do any,
Okay.
did you do any individual voir dire on those groups?
I started off, on the hardships I did. On the whether or not they could be fair to Mr. Cruz, initially I did, but then the lawyers agreed that it wasn't necessary because if they raised their hands and they couldn't be fair and impartial, it was pretty clear. Based upon my questioning, I'm happy to give you the outline that I read up to both sides. I mean, it was probably on TV, and I read it like 4, 7, 10 times a day. I don't know, but it was about the same thing.
The one difference from listening to your last experience
Sure.
with this defendant was that guilt is not an issue. So if there's a bias as to guilt, that's not a reason any longer. It's a fairness towards the penalty.
Sure.
So
I would just have to rephrase it, and I'm happy to let you all tell me exactly how you would like me to phrase it. Why don't I do this? I'll have my assistant email both sides my outline from the last trial. And then you have it, and you can look at it and tell me what needs to be changed, if I need to redo the whole thing. Obviously, the charges are going to be different. And it's not going to be emphasizing that this is not the homicide case, because it is the homicide case. But you'll get the gist of what was read and what you think needs to be changed. Okay? I'll get that to you today, and then if you all by next week, let's say Monday, November 1st, if you would please just get me your outline of what you would like to do, at least the number of jurors that you would like. By January, we might be able to do 75, groups of 75. Sometimes I think when groups get really big like that, it makes it a little bit more difficult, but whatever you all think, I am fine with it.
And the only other thing we have is waiting for their announcement about the mental health.
And that's going to be by Friday, Mr. Wheeler?
Judge, Ms. Curtis.
We're working on it.
Well, because Ms. McNeil and you were the ones that told me last week, that's why I asked you. She said by Friday, so I'm sure she'll give it to you by Friday.
Okay.
If not, you all can let me know, and I'll have another hearing, but, that's what she said, that's what I expect. Okay, so,
Let's still want to pick days.
yes, let's do that, just give me a second, please. Okay, how about we have November 3rd at 1:30 for the afternoon with the tentative motions that I'll do a written order outlining them so that we have a documentation in the court file. The following week, I can do either Monday or Tuesday or Wednesday afternoon.
Judge, we have definitely holiday, the 8th, which is Monday, and Wednesday, the 10th, but we're clear on Tuesday. Good night.
Are you clear?
Is there a deposition?
Probably.
I'm kind of speaking for both of us.
Will we need a week later, less than a week later, another afternoon, or should we do it every other week?
Yeah, for now, let's do that. I mean, if you can start generating more, then we can set more.
Okay, so how about the 15th?
We have that one. That was for those two search warrant motions. 164, 65.
November 15th at 1:30. And anything, if you don't think those will take 4 hours, then we can, you could just let me know, we'll add other ones. So that's the 15th, and then how about the week of, the following week is Thanksgiving, how about the week after Thanksgiving? I can do any day that week, it's the 29th, 30th, 1st, 2nd, 3rd.
We have definitely the 30th and the 1st, and for many other days. So either Monday, Thursday, or Friday.
How about, we'll keep it Monday?
What's the date?
Monday, the 29th at 1:30?
Your Honor, can it be later in the week?
Sure. Did you say the 1st you were available? That's Wednesday?
No, Thursday, the 2nd.
Thursday, the 2nd at 1:30? Going once?
Thursday, December 2nd at 1:30?
Yes.
Yes, that's fine.
Okay, so for the month of November, just to rehash, we have Wednesday, the 3rd at 1:30, Monday, the 15th at 1:30, then we have December 2nd at 1:30, and then, how about,
Because I'm not sure I'm sorry, I'm not sure we're available on the 2nd. What was the other day now?
Friday is the 3rd. I want to have a hearing that week, because the week before we won't have a hearing.
We're just waiting.
We're gonna.
Your Honor, we can do things on November 12th, we can do the hearing in the afternoon. We do have a deposition in the morning, but we can do it in the afternoon.
We're not,
November 12th?
where'd you get November 12th, Ms. McNeil? Are you on a delay?
November 2nd. November 2nd.
Okay, no,
December 2nd.
December 2nd.
Oh,
Is that
I'm
what you
sorry.
said?
And we're gonna need some time, Your Honor, to take depositions of their witnesses, and we have no idea.
I mean, these dates, if there's nothing to be heard, we can cancel them. I just want to coordinate it now so that
That's
we
fine.
have those days, and so I don't schedule anything else. So, Ms. McNeil, the 2nd of December is fine, or you're not sure?
Those dates are held for the federal agents' depositions. If that doesn't move forward, Judge, then you can tentatively schedule it, and we'll let you know if there's an issue with those depots.
How about the 3rd?
Same, federal agent depots.
And we can't do it the 30th or the 1st?
The 30th, we have deadline scheduled all day.
Do you want to do it the 22nd, November 22nd or 23rd? That's the week of Thanksgiving. I
All
don't
right, I think
know.
we're gonna skip that week, so, because
Okay.
we're doing one day every other week. So the best day you're telling me is, what time do your depots start on the 2nd? Is there a chance they would finish earlier and we could do it at like 3 o'clock?
December 2nd, is that what you said,
Yes,
Your Honor?
yes.
I don't know how late they're going. I mean, if you wanted to,
No, those aren't deposition days, Judge. That's something, we have some meetings scheduled on that day. That's
She
second
said
and the
federal
third.
agent depots.
no, we have them set aside for federal agent depots. The 13th in the afternoon is good. There's only one depot in the morning.
Wait,
The 14th is open.
wait, Ms. McNeil, we're on the week of starting November 29th to December 3rd. I'm trying to find an afternoon that week or a morning where you all are available.
And I don't show that we're available, Judge. I show that the first, second, and third are depositions of federal agents.
All right, so then I'm gonna skip that week, and then the next week we'll have 2 days. So how about December 6th and 7th?
The 6th, we're definitely one day, the 7th, 8th are clear, and the 10th are clear.
All right, how about the 7th and the 8th from 1:30 on?
May I have a moment, please?
Sure, this is
I'm just going to
December.
check with my legal assistant, if I can just have a moment, because these dates are being held, and I just need to verify that. If they're not, it's just going to release them. Just a moment, please.
Okay.
Your Honor, I'm back. So December 7th, the whole day, if you want to reserve the whole day.
Okay,
December 8th, we have a deposition, we're done at 1:30, so we can do the afternoon of December 8th.
okay, so I'm setting December 7th. I'm gonna start at 10:30, and then we'll take a lunch break, and then we can come back in the afternoon. That's why I can do my other docket first. So we'll start December 7th at 10:30 for the entire day with a lunch break, and then on the 8th at 1:30.
And if for some reason that deposition on the 8th does not go forward, we'll let the court know that we might be able to open up the morning.
Okay, and then how about the following week? Because that will pretty much be, we at least need, I think we should do 2 afternoons the following week, which begins the 13th and is the 17th.
So the 13th in the afternoon, Your Honor?
Judge, that's fine.
Okay, the 13th at 1:30.
The 14th is open. The whole day we would request, Judge. There's about another 14 motions to suppress, so we can take those days, the whole day of the 14th.
See?
That's fine, Judge.
Okay, 14th, all day. Do you think that's gonna be enough, or do we need another day?
Let's just block it out, Judge, and then if we don't use it, we don't use it, but at least we have it clear, if you're comfortable with that.
I agree. Do you wanna do the,
December 16th, there's no depots, that's open all day.
Judge, we're very concerned about having days for deposition.
I understand. If there's days that you have to take out, we can do that, or we can do more afternoons, so that you can do depots in the morning. if you're uncomfortable blocking the whole day.
But we're talking about motions that we haven't even received.
No, I know.
We don't have any witnesses.
Okay, so let's do this. We're gonna block these full days, and then when you all find out if you need the morning or the afternoon or the whole day, we'll just cancel it. This way, at least we have days set aside, and if you all need to use them for other things, then you can let me know. But at least at this point, if everyone's available, we can set them aside. If you need me and there's things that need to be heard and are ready to be heard, we'll use those days. With the understanding that you can, that's without prejudice, okay? Ms. McNeil, you said the 16th?
Yes, ma'am. And all those motions to suppress I'm referencing, Mr. Marcus, those are the ones that have already been sent over. We just haven't filed them yet.
All right, so if you all can make sure your witnesses are available either the 13th, 14th, or the 16th. We have the 16th all day, the 14th all day, and the 13th at 1:30. And then I think we should have one other afternoon after the Christmas holiday, maybe the 28th or the 29th or the 30th.
Any of those dates are fine. And I don't know if you want to also set a date for jury instructions.
Well, that would be, I generally don't do jury instructions until towards the end of a trial. Do you do it differently in this type of case?
Yes.
Well, there's a lot.
There are preliminary instructions also prior to them.
But only, I looked them up, there's only a couple pages. But there's some things that you all say apply, that some that doesn't, to the preliminary, the death penalty preliminary instructions.
Yeah, you want to tell them what the death penalty procedure is.
Okay. So let's do the 29th in the afternoon. Do you think an afternoon will be enough for that?
Yes, because I think that we can work with the state to come to agreement on some of the stuff, and anything outstanding we can use for that date.
Okay, the 29th at 1:30. You know what, I'm gonna just tentatively reserve the 28th at 1:30 also, just in case. So do you all want me to read the dates again, just to make sure we have them, or you're everyone's there? I have Wednesday the 3rd at 1:30, Monday the 15th at 1:30, December 7th, starting at 10:30 for the whole day. December 8th, Wednesday at 1:30. December 13th, it's a Monday at 1:30. December 14th, Tuesday, all day. December 16th, which is a Thursday, all day. December 28th, which is a Tuesday at 1:30. And December 29th, which is a Wednesday at 1:30. And I'll do a written order listing all of the dates that have been set aside, as well as the specific motions that are set to be heard on November 3rd and November 15th. Okay, and if there are, let's say there's a motion that you all agree to, or it's not right yet, if you all get together and you say, okay, so Wednesday we're set for A, but why don't we do B, and you all are in agreement, that's fine with me. Just so that we can try to have something ready for each of the dates. I mean, I don't want to waste time. If we don't need to have those dates, we won't have them. But if there are outstanding issues, I'd like to try to get to them as efficiently as possible. Okay?
Just one last thing.
Sure.
Can we get an order, and obviously I'll show it to the state first, just an order reflecting the court's holding the PSI in advance?
Yes, I'm going to do that. I'm going to do that as well. Okay?
And just one more thing, Judge, this is Melise McNeil. So candor to the court in reference to our mental health experts, and I told Ms. McCann and Mr. Marcus this last week when we had this discussion. Our experts have not completed all of their evaluations. They're still scoring some of their raw data. So we can list them, but I don't know when they'll be eligible or available for depositions until their examinations and evaluations are completed. but that is all in the works.
Okay, but just make me out, I'm gonna tell you, just like I tell the state, unless it's like some kind of emergency, then this has to be a priority, okay? Please.
Oh, no, and it is. I want the court to know what's going on so that you're aware.
Okay,
And I told the state this as well. I just wanted to have candor to the board about the process.
okay.
Thank you.
So other than that, I will see you all on November 3rd at 1:30. And, Ms. Bailey, my lovely officer assigned to this division, will you please, I'm gonna give you the order, but will you make sure that, the Department of Corrections knows not to start the PSI? Until I hear from me?
Yeah, sure, I'll let
Okay,
them know.
thank you, so she'll take care of that, and I'll write the order, okay?
Thank you.
Okay. Thank you. All right, the Cruz case, unless there's anything else, is in recess, and I'm gonna shift back to my other docket.
Judge, I know you just mentioned it, but just very quickly, in the event that the experts we have clients or they're teaching, this, as the court has said, is a priority, and they will be needing to make themselves available for the dates that. We're just concerned that they're not going to have dates available and that they're going to have to clear their schedules just the way our witnesses are going forward.
I think that's the understanding.
We just want to make sure that your experts know that they need to have their schedules cleared just like our witnesses and that we're not going to be fighting over dates.
No, not necessarily clear, but they're gonna have to be available sometime. They're not gonna be able to say, like, I'm not available for 6 weeks. because
Right,
I have blah, blah, blah. So
We
this
don't
is-
intend to.
Okay, well, not that you would, but even if they might think that, some doctors are easier to work with than others.
Your Honor, if I may, I just want to remind the parties that under Rule 3.202, time for filing the notice and contents, that the defense has a burden now of not only providing the names of the witnesses, but the notice shall contain a statement of particulars listing the statutory, or actually you're also saying now, all mitigating circumstances the defendant expects to establish through expert testimony in the names and addresses of mental health experts by whom the defendant expects to establish mental mitigation as far as possible. To the extent that we've only been talking about giving us the names of their witnesses, they have a further responsibility of providing the mitigators they intend to use.
Okay. I'm sure you're aware of that.
We've cited that rule numerous times in here, Judge. We are aware of it.
Okay. All right, thank you.
Thank you, Judge.
May I see, before I start my other docket, just off the record, may I see one lawyer from each side on the Cruz case, please?